The contracts question from July of 1988 is yet another contractor question. Here's a hypothetical that is strikingly similar to every contractor question to appear on bar exams and law school final exams all across the United States over the last many decades. Have a look at the call of the question with me. After receiving evidence of the above facts, the trial judge, sitting without a jury, ruled 1. Cobb had breached the contract but could recover $8,000 on his claim. 2. Cobb's recovery would be offset by $5,000 as damages to Owen based on Cobb's breach of the contract. 3. Owen could not recover any amount based on the liquidated damages clause. Then we're asked, were the rulings of the trial judge correct? Well, we can't even really outline an answer to this question before we carefully read what happened between these parties. The fact that we've got dollar figures mentioned in the first two calls of the question tells us that this is almost certainly going to be about damages. And the fact that we've got parties named Owen and Cobb strongly suggests to us that we're going to be dealing with an owner and a contractor. With regard to the liquidated damages clause, this seems like the shortest and simplest question presented. In order to answer it, we have to examine the liquidated damages clause in the pattern. And up front, we remember the rule. A liquidated damages clause is enforceable so long as it is not punitive. We've got to have a reasonable liquidated damages clause, and if it is reasonable, we will enforce it. So it looks as if the trial judge has examined this liquidated damages clause and ruled it to be unreasonable or punitive. We're going to have to look at the facts and determine whether or not we agree. Go to the top of the problem, and we've got a key fact up front. Owen enters into a written contract with Cobb, and Owen hasn't shopped around first. Owen didn't look for other bids. Owen just took the first offer that he got. The first bid is the bid that the owner goes for. We see that there's a $20,000 price tag on this remodel, and Owen gets to live at home while the contractor's doing his remodeling work. Any problems in paragraph 1? No. This seems fairly straightforward and simple. In paragraph 2, we see an initial payment of $2,000, and the other $18,000 is going to be due upon completion. There's a date for performance. The job has to be done by November 1 of the same year, and we have a liquidated damages clause in paragraph 2. So let's have a look at it together. The contract also provides that in the event of delay in completion, the amount due Cobb from Owen would be reduced by $500 for each month or part thereof of delay. Well, how do you feel about that liquidated damages clause? To be honest with you, it doesn't look very punitive to me. The amount of damages is a very small fraction of the entire contract price, and so my initial inclination is to say that the judge got it wrong, and that this liquidated damages clause really is okay. So let's read on. In paragraph 3, we have a breach by the contractor. The contractor does half the work, and then he realizes that he made a mathematical error at the time of submitting his bid, and so he says, I've got to quit because I can't afford to continue this job. Well, here's where the fact in the very first line of the question becomes relevant. Owen didn't seek other bids. There's nothing in this pattern to suggest that Owen somehow is taking advantage of a mistake by the contractor. And so my conclusion is that the contractor can't walk away from this agreement based on the contractor's internal math error. This is a situation where we've got grown-ups who are making contracts with one another. Nobody's trying to take advantage of the situation. And so my inclination is to find Cobb to be in breach and to find this breach to be an unexcused breach. Now, we know that the contractor is going to be able to interpose some defenses to this breach, primarily based on commercial impracticability. And, again, as often is the case, one might be able to craft a reasonable answer that reaches the opposite conclusion that I reach. But I think that my answer is as usual, certainly the majority answer. The contractor's on the hook. We're not going to excuse his performance based on his own unilateral math error. Then in paragraph 4, now the owner goes out and gets other bids. He takes the lower of the two bids, and we've got prices. So it's going to cost $15,000 to contractor number 2 to finish this job. And within paragraph 4, we find out about an additional series of shortcomings with the contractor's performance. We see that the contractor had put in the wrong kind of paneling, and so $1,500 of this new bid is to fix this paneling. The contractor initially put in deficient paneling, and now we're going to get it right. And we see that the job is finished by contractor number 2 on December 1, a month late. And then we have the predictable lawsuits. Cobb sues Owen to recover the value of the work he did up to the point he stopped performance. Okay, what does that mean? It means that the contractor is seeking restitution. The contractor is not seeking damages under the agreement, but is seeking to be compensated for the benefit conferred. Now, in almost all jurisdictions, this contractor would have a right to do that. But in some contractors, a contractor who walks off the job under situations like this would be viewed to be a willful breacher and wouldn't get anything in restitution. But by and large, the rule is contractor is entitled to reasonable payment for the value of services when the relationship between the contractor and the owner breaks down. Then we have the call of the question, where we find the rulings of the judge. Now, with all of this background well in place, we're in a much better position to be able to organize our answer to the question. Have a look at my outline of issues. You'll see right up front, I focus on the contract claims. I talk about formation, and I talk about Cobb's defense to formation, his unilateral mistake in making this math error. Then, ultimately, I'm going to conclude that we've got a valid contract. We've got two different breaches, as is so often the case in these contractor cases. The owner, Owen, has paid up front but won't pay the balance, and Cobb won't finish the job. So the relationship is broken down completely. Both parties could be said to be in breach. The defense to breach on the part of Cobb, severe impracticability. Obviously, Owen wasn't obligated to make the final payment until the job was done. Then we turn to remedies. And here, we narrowly and specifically examine each of the rulings made by the trial court. Here's where we actually provide a straight answer to each question presented. So Roman numeral 1 of my outline of issues, the first section of my answer, is discussing the contract and establishing the relationship between these parties. That's really necessary before we can go into an analysis of answering the exact questions presented. Now, could one frame an answer that just starts off with an answer to call of the question number 1? Answer, yes, but internally, we'd still have to establish the existence of the contract. So, once again, I have selected an approach that is more time efficient. It allows us to cover all of the issues with a greater economy of time, and that allows us to focus our attention on analysis. So with regard to the first ruling, the court is finding that the contractor has breached the agreement. We agree. In a couple of different ways, the contractor walked off the job and the contractor used the wrong kind of paneling. Next, we find that the court is finding that Cobb can recover $8,000 based on his claim. Well, up front, we might react that that's incorrect because we know that we're going to reduce that recovery sum based on the other damages issues. So, we will consider the $8,000 ruling in light of the subsequent ruling. The second ruling is we reduce the recovery by $5,000 to Owen, and here we like what the judge did, because Owen sought substitute performance and he shopped around for it. And Owen is entitled to get the benefit of his original bargain. His bargain was a remodeled house for $20,000. Then we turn to the liquidated damages clause issue. And here, my assessment is the court got it wrong. I would reduce Cobb's recovery by another $500 based on the liquidated damages clause. Now, you don't have to agree with me about that one, but certainly we've got to analyze the facts and apply the rule to the facts and reach some conclusion. Now, very briefly, turn with me and have a look at the model answer that I provide. You'll see right up front I get into formation and I get into the facts. In particular, I am focusing on the terms of payment, the price and the down payment. Then we turn to Cobb's defense to formation. And my assessment is that this is not a sufficiently big mistake to allow Cobb to escape liability under the agreement. Now, I can imagine one writing an answer that reaches the opposite conclusion. I don't think it's on very strong ground legally, but one certainly could do some fairly sophisticated analysis and reach the conclusion that Cobb ought to be excused from performance based on the gravity of his mathematical error. It isn't unreasonable, but I don't think it's the best answer. Then we turn to breach, and here we see that we've got an owner who's got a job that is not nearly done and that requires a bunch of remedial work also. Then we turn to the court's rulings about the breach by the contractor and about the amount of money that can be recovered. Now here again, as you go through my answer paragraph by paragraph, you'll see that I'm focusing on what happened. I'm focusing on the facts from the pattern, and I'm interpreting those facts based on how we understand the contract principles that are going to govern resolving a dispute between a homeowner and a contractor. In the end, I like the court's reasoning, and I agree with every step of it until we get to the liquidated damages clause. Now here, it does seem to me that although it could be considered a close call, my assessment is that the court erred, and that Cobb's recovery ought to be reduced by an additional $500 based on this liquidated damages clause.